So before understanding the advantages of the legal notice, we should know what is a legal notice. So nobody can enter a court, especially plaintiff cannot enter the court. Plaintiff means one who files a case in the court, cannot enter the court without losing something. That is, the defendant against whom the plaintiff wants to file a case must cause damage to the plaintiff. The defendant must fail to perform a duty and thereby resulting in the violation of the right of the plaintiff, thereby plaintiff losing that right. Then only plaintiff can enter the court premises. It's not just like entering into a mall. There should be a cause of action, and that cause of action must be set into motion by the defendant. The defendant must damage the plaintiff. Remember this. When these facts are brought to the advocate, advocate applies law to those facts, because violation of the right cannot be claimed without the same being informed in the law. The law has to proclaim that there is this so and so action means violation of right. If that fiction is not created by law, then legal notice can't be sent. So whenever you bring these facts to the advocate, advocate applies law to those facts and alerts the defendant to come forward to solve the problem, to give back the right to the plaintiff, to redress, to seek remedy, to solve the problem. That is an opportunity that is given by the plaintiff to the defendant. It is a practice. Now, is it compulsory? No, it is not at all compulsory. Until and unless it is told by the law, it is proclaimed by the law, it is not compulsory to give a legal notice. For example, for check bounce case, legal notice is compulsory. For filing a case against government, legal notice is compulsory. For filing a case using demand promissory note as evidence, legal notice is compulsory, because you have to make a demand. And a demand promissory note, demand is more important. So how will you make a demand? By sending a legal notice. So until and unless it is proclaimed in the law, you cannot, there is no need for you to send a legal notice. Now, what are the advantages? The point of the topic. Through the legal notice, one advantage is you can claim the expenses that you spent on the legal notice when you get a decree. So that is the monetary advantage anybody can claim as a matter of right under Order 20A of Civil Procedure Code. Whatever the expenses incurred for sending the legal notice, you can claim as costs, provided you get a degree. That is the first monetary advantage. The second advantage is you will know the mind of the defendant, so that you can create a strategy for your case. Remember, legal case is always technical in nature. It is scientific in nature. It is logical in nature. It is common sense oriented approach. Never emotional. Court will not become emotional. Law will not become emotional. Advocate will not become emotional. Because there is no sort of emotion left in the book or the court. It is logic, technique, scientific in nature, common sense in nature. So therefore, to know the mind of the defendant, you have to shoot in darkness. So sending legal notice is shooting in darkness. Sometimes in the transactions between the plaintiff and the defendant, there will be no evidence. You can even collect evidence through a reply legal notice. If at all he replies through emotion, you will get some material. You can use it in court in writing your case before filing. So you can collect evidence, you can know the mind of an advocate. Sometimes you can settle the case also through a legal notice. So that is one advantage. You can draft your case strategically, that is another advantage. And the final advantage is the address of the defendant will be confirmed. Because always remember, if there is no notice, there is no case. There is a fundamental policy, fundamental principle of courts. So he may refuse the notice of the court, but he will not refuse the notice of the advocate. He will simply receive it because it will be a surprise to him. He will not yet get prepared to reject a notice because it will be out of surprise. So his address will be confirmed, and tomorrow if he rejects the court summons, you can inform the court that he received the legal notice, but he is rejecting the court summons. And therefore, you can pray the court to pass an order affecting proper service. So if he rejects also, court can consider that as proper service, provided you convince the court that he received the legal notice. So therefore, there are many advantages of sending the legal notice. I have outlined only a few advantages. So you must send a legal notice so that you will know the mind of the defendant. Okay. Thank you. Thanks for watching. I am leaving the format of a legal notice in the description box. Kindly go through it and use it as a reference. You'll understand more if you just read the format. How a legal notice must be drafted. It must set the facts of the case. It must set the violation of the law based on those facts. And you must give an opportunity and a time to redress the remedy to the defendant. That opportunity must be encashed by the defendant. If he is not interested to redress the grievance, then he will suffer a court case. Okay, thank you. Thanks for watching. If you have any doubts, kindly comment. If you like, kindly share and subscribe.